think he mentioned bail. I mean, it's realized. Good morning. This is Senate Judiciary. Today is January 24th, 2024. We're taking up the issue of bail. There's 3 bills dealing with bail in this committee. It's a popular subject, and some of you may have the document here from Council of State Governments, Justice Reinvestment 2 Working Group, January 15th, 2021, and I'll point you to some relevant sections. And I think some of the recommendations have not been put into place, particularly in terms of risk assessment, in terms of identifying new or existing tools to identify risk factors that can be targeted with treatment and services. So when somebody's left in the community, I have the feeling nobody's supervising them, then the judge finds out they didn't go to treatment that was ordered, or there's been no actual supervision of the individual, and then there's violations of conditions upon violation of conditions, which frustrates the communities, frustrates law enforcement, frustrates constituents, you name it. So that's where we're at. So people are saying it's our bail laws. I'm wondering if it's not only maybe our bail laws to be reviewed, but certainly what we do about violations of conditions of release. So I would really like that to be the subject of whatever we do in terms of bail, is how do we deal with violations of conditions of release. So with that, we have an expert from Vermont who happens to work for the Council of State Governments Justice Center and happens to live in Vermont. And she's the Deputy Program Director for the Justice Center, Ellen Whelan-Worst. And Ellen, you're on Zoom, and I think you have Carl Reynolds with you today. So
I do.
Jump in on this issue. But I think you remember the 2021 working group report. Was you a part of that group?
I was, yeah, although I haven't read it in a minute, so I should have reviewed it before meeting with you all. But I am joined by my great colleague, Carl Reynolds, who I will say is actually an expert on these issues in a way that I am not. I am a Vermonter, but and I worked on justice reinvestment too, very closely with folks in the room. But Carl and I have been going back and forth since Ben reached out from the committee a couple of weeks ago with some initial questions. And Carl is putting together a memo that we can send to you all, if that would be helpful. It really sort of does a beautiful job of pulling together case law related to bail in Vermont and different Supreme Court cases and things that have weighed in on this issue. So we can offer, and Carl, I would hand it to you to kind of give a first review of our understanding of kind of where bail stands and what the proposed changes in the bill might mean. But I would also really welcome questions from the committee if we can be responsive to what you all are thinking about, or directions that you're thinking of going in, because that will help us understand more where we could give you examples from other places or best practices or ideas of just, options that might be on the table for Vermont. Does that sound good to everyone?
Yeah.
Okay. Carl, do you want to give a first sort of overview from what you had put into that memo draft?
Sure. Thanks, Ellen. Good morning, everyone. Carl Reynolds. I'm down in Austin, Texas. I'm a lawyer by training and sort of a graduate of Texas state government working on these issues. I would kind of disclaim true expertise on bail law in general or in Vermont, but I have spent some time looking at some cases over the history of this issue for the last couple of decades, few decades, since Vermont passed a constitutional amendment allowing for people to be kept without bail who represent a particularly dangerous subcategory. So your constitution was amended and your statutes were amended for that issue. I think since then, what I see in the law and in the case law is an effort to, as some of the cases say, ensure that our jail population isn't inflated by just setting high bail for people to keep them in jail. And even some efforts in 2018 to ameliorate the bail laws to some extent from the defendant's standpoint, make it more likely, I guess you would say, that a judge would be empowered to not, well, first of all, give someone a PR bond essentially as a first option, but restricting the amount of bail that can be set for certain misdemeanors, basically things in the direction of guiding judges away from keeping people in jail on bail, essentially, but unable to meet bail. But in 2017, your Supreme Court held in a case called Pratt that I would commend that case to all y'all because it really sets out this history of bail law in Vermont, except for the things that have happened since 2017. And it makes clear that that in some instances, a judge is able to set bail in a way that knowing that the defendant can't meet the bail, even though the judge has thought about the defendant's means, their ability to pay. And in that case, where I think reading it and reading the facts, you sort of are rooting for the judge being able to keep this fellow in jail. And but it's a close question. So that's kind of the backdrop that I see looking at both the statutes and the case law. And then the bill, you mentioned 3 bills, Chairman. I've only looked at one current bill. It was S-159, I believe. And it's a fairly modest change, I think, in the current law. Right now, the law says when a judge is wants to decide not to grant someone a PR bond, they have to take into account the person's criminal history, essentially, what's going on right now in their history and the severity of what's happened. And so the bill amends the next paragraph to say, if you've gotten that far and you're thinking about setting conditions on the person, think about those things also. So it's to me, a fairly small change in the current structure of the law. And getting to the issue of violations, what I see in that chapter of your statutes is a pretty typical array of, arresting someone, pulling them back in. I don't see anything obvious lacking in your system of dealing with someone that you realize has committed that kind of a violation. So I don't see a need for legislation in that regard. But one thing that does occur to me is you have a home detention option that the Department of Corrections has a say in. They have to approve the person that someone's going to have home detention with. And that doesn't happen very often, apparently. But your Department of Corrections is the only game in town in terms of having the capacity to supervise people. And so I would be curious, and I realize the director is in the room, I'd be curious to talk about what it would look like for the DOC to have greater capacity, more resources in order to get at the issue that you stated at the outset. That's kind of where I've landed in terms of thinking about what we assumed was the presenting issue.
And I'll just say a couple of things that Carl and I were just talking about yesterday before meeting with you all this morning. There are certainly examples in states where there are different systems that can be put in place to ensure that a person appears at court, right? So when you're setting bail or when you're detaining someone pre-trial, the concerns tend to be harm to the community, right? That if a person is allowed to remain in the community, that they might continue to recidivate, to commit new offenses, or potentially to put the public in danger, and or a concern that they won't return to court when they're supposed to, right? That short of detention, that person may not appear. So Carl and I had started to talk about, different systems that and even notifications that states have put in place to remind people when their court hearings are happening. And there's actually been some strong evidence to show that that's effective if that's the prevailing concern. My assumption, and this is where I would ask the committee members to just confirm kind of the discussions leading up to this bill 195 have been. But my assumption is that it's also, if not more so, about the behavior in the community while someone is awaiting trial but not being detained. That people are continuing to commit offenses, or there's concern that they will, and that there is potential danger to the public in that person not being held on bail. So if it's that issue, and this is where Vermont's tricky because there's not really a county court. Well, there are county courts, but there isn't a county supervision system. Of course, there are no county jails or local jails of any kind. We only have the prison system. And that's why Carl mentions that DOC is sort of that is the agency that provides all community supervision in Vermont right now. In other places, what you sometimes see, especially where there might be courts that have their own capacity for this by way of personnel and resources, they will conduct a pretrial risk assessment. And part of that pretrial risk assessment, a big focus on those tend to be the concern around failure to appear. How likely is this person to return to court when they are supposed to be? But it also takes into account other risk factors, right? Other potential for a person having a really hard time remaining in the community without getting in, frankly, more trouble. And what would they need by way of support or supervision or both to ensure that they come back to court when they're supposed to, and that they also don't continue to act in a way that is against the law or that could lead to their rearrest. So there are options in certain places to do pretrial risk assessments and then to focus pretrial supervision, if that exists or can exist, on the highest risk individuals, people who are, at highest risk of struggling if they're if they're in the community and not being held pretrial. So that's a long way of saying it would be really helpful to hear more from you all, or if you have any questions that can guide us on the main concerns before this committee that you're grappling with. And then we can continue to sort of offer ideas and refine some of what we've looked into and see if that's helpful.
My main concern, and I think that of many members of the committee, is the violations of conditions of release. So someone goes before a judge, they're released, and there's conditions set. For example, you shall go to screening for alcohol or substance abuse dependents. They refuse to go or just don't bother. Then they don't show up for court. And that's a further violation. And then there's more violations, new crimes, for example. It might be minor crimes, but there's new crimes alleged. Then we have a community that sees the system as catch and release, that the police catch them and then the courts release them. Back in the community before the police even finish the report. That's the narrative. The second thing, you're absolutely correct. Once someone is held on bail, they immediately get into the Department of Corrections, DOC supervises, unless they're on house detention, which Carl mentioned. I believe there's only 6 people on home detention right now, out of all of the ones that are, and so it's very rarely used. And House Corrections and Institutions is looking at this, how to expand it. But at any rate, there's no supervision. So somebody's released from jail, you had bail set or no bail, and there's a weight of evidence hearing, and the judge decides to release them. Nobody's supervising. Not only that, the day they're released, it's no longer anybody's responsibility. So they walk out of the correctional center. Let's say they have a problem with opiates. and they're on, some kind of a, methadone or Suboxone or whatever, there's no follow-up, there's no to check on where they go, so they go out and many times are right back into the illegal market. So those are some of the problems that I would like to see addressed. I know Senator Bahowski may have a different view, but she may have a question, but I think that's the state of the general public in Vermont right now. And they're calling for reform of our bail laws. But I haven't said what that reform should look like. I think it's just hold more people. But back in 2018 and in 2021, I don't think anybody said don't hold people accountable. Just find alternatives to incarceration to hold people accountable. What's happened is I don't think we're holding anybody accountable. That's my opinion. Senator Bahowski and then Senator Sheen.
Yeah, I don't know that I entirely disagree. I think we do need a system of accountability, although, as you know, I have issues with cash bail, and I think there's a general lack of understanding for how we are even using or supposed to use cash bail, which leads to some of this narrative because people don't understand why we can use bail. But my question for one or both of you is if either of you can speak to either the federal system that doesn't utilize cash bail or the states that don't use cash bail and what their systems of pretrial supports and services are to hold people accountable.
Christina Nolan is our next witness, and she's going to speak to that. The federal system.
Yeah, and because I actually agree with you that we need a better system of pretrial support services and accountability. And so I'm just wondering in states that are not, or any jurisdiction that is not utilizing cash bail, what those systems look like.
Carl, can you think of anything off the top of your head? I would need to look. I mean, there are not many states that have moved fully in this direction. Illinois recently, I mean, within months, just got rid of its cash bail system, not without a lot of controversy, right? And we were just reading some early reports yesterday or the day before about how the whole world hasn't fallen apart, right? Which was sort of a prevailing concern and narrative that crime would spike. So we could definitely pull up some more information. I can't speak to the federal system myself. I will say there's no question that, and just understanding what I've learned about Vermont's bail system, which wasn't the focus of Justice Reinvestment 2, partly because it was, that initiative started a year after the bail reform of 2018 had gone through. So we were really looking farther down, which means I can't quite remember. It's been a minute since I went back to my notes to try to remember when people are receiving risk assessments in Vermont. I think it's post-sentencing. I don't believe it's pretrial, but certainly folks in the room or others will be able to tell you more specifically. But Vermont has moved towards, I think, a system or sort of interpretation of bail and the use of bail that we would advocate for, which is understanding that bail is meant to be used to either truly focus on the greatest protection of the public, right? From people, to try to find a way to ensure that someone who feels very, very dangerous is not immediately or maybe at all released while they are awaiting their trial. And I will say that even in the case of like domestic violence, for example, I was just talking to a colleague of ours, David Demora, who worked in Vermont extensively, that in some cases, setting bail at 72 hours after someone has been brought in on a domestic violence charge is enough to ensure the safety in that situation that is necessary. So it doesn't mean that even the most extreme situations that bail has to be removed to protect the public. But you sort of have that option. And then it really is understanding that bail is meant to ensure that someone appears for their court, for their court proceedings, that they return to continue engaging with the process. So Vermont has built that into its interpretation in the laws from what we have read. And people who are pre-trial are not necessarily different than people who are on probation, people who are incarcerated, people who are on furlough or parole, in that they have co-occurring behavioral health disorders, they have a criminal history, they have a history with trauma or whatnot. that requires supervision for accountability, but also potentially for support and also treatment and other connections to care. And the community supervision system in Vermont, and certainly when it's really, you know, working as you'd want, is sort of achieving all of that. And so you have folks in Vermont, like you're mentioning Senator Sears, who are awaiting trial, and it doesn't mean that their risk or their needs are different than if they've been sentenced. It just means that they're not necessarily being supervised, or and sometimes that supervision, you know, it sounds like oversight, but sometimes that's also a person who's just working with you to make sure that you connect to both you know, you're meeting the conditions of your release, but in many cases that's treatment or other things that could really help that person address some of the underlying issues that might be driving their involvement in the criminal justice system. So obviously painting with a broad brush, because we're talking about individuals and as though there's one type of person and there isn't. But I think it's worth understanding more about how a targeted, right? You don't want to apply it too broadly because then you water down the resources, but a targeted approach to supervising folks pretrial, if that's possible at all. Because if you do assess people and you identify who's at the highest risk, highest needs, you can connect them and supervise them, and there's not built-in accountability, but certainly research shows that just incarceration leads to more likelihood of plea deals that lead to likelihood of further incarceration, in sentencing, longer sentences. So it doesn't necessarily play out downstream to the advantage of sort of making sure that you have a healthy management of a prison system. Like in Vermont, you don't have county jails where they're holding folks, so they're all going to go into the prisons.
Go ahead.
Yeah, as a follow-up to that, and I appreciate that you don't have the, you know, information at your hands to speak to some of the systems that exist. Is there somewhere, or do you know, sort of best practices for pretrial support and services?
Absolutely. I mean, I would have to pull those resources together for you, but there's one immediate resource is the Pretrial Justice Institute, PJI. They have a ton of research and a ton of resources that are immediately available, and that's certainly somewhere that we go to try to learn more. And then we have colleagues who work strictly on pretrial and bail issues. So we could certainly go to them and try to get some more resources to pull together to send to the committee. That's no problem.
Thank you.
Thank you. This has been extremely helpful. I guess, you know, our dilemma is that there's nobody currently supervising people who are on bail, and those released from institutions who were there detained, they're not supervised by anyone. So the day they walk out the door of the institution, they're immediately back into the community with no necessary supports. So it's a situation designed to create a failure, quite frankly. That's what troubles me, and that the more I've supported most of these reforms over the years, and I'm beginning to question that particular phase of it, and that is what we do when somebody violates conditions of release. So I come right back to that problem, and I don't want people going to jail necessarily for violation, but I want them, if they were ordered into treatment, I want them going to treatment. If they were ordered to do this, that, or the other thing, I want them to do it. And then if they refuse, then that was their choice, in my view. So that's where I'm stuck. And whatever, I don't know how you write that in the law, but I think that we need to have, I know in Massachusetts, I believe probation and parole is attached to probation is attached to the court. So the court orders the probation officer to continue to supervise the person that's out on conditions.
Yep, I think that's right. And I was thinking about Rhode Island too, Carl, where the courts had moved strongly in the direction of pretrial risk assessments and trying to work with. Rhode Island also has a unified system like Vermont's, where all supervision happens under the Department of Corrections, but the courts were working very closely to try to institute some of those types of reforms there as well.
Well, a big start would be just having pretrial screening and, a screening tool, an assessment. We're pretty good at that. We have a lot of assessments to assess not only the dangerousness of the individual, but what the individual's needs are. And it may be that it's available in the community. And that was, I know that this was about revocation. But what was suggested was prioritize 3 interrelated areas of study regarding mental health and substance use as outlined in Act 148 with a report due to the legislature in January 21. And one was to determine a screening, assessment, case planning, and case coordination gaps for people with complex mental health and substance use issues in the current criminal justice system and recommend system improvement. 2, identify ways to increase Department of Corrections and community provider risk assessment information sharing, help inform plea agreement, sentencing, and revocation decisions. And 3, identify new or existing tools to identify risk factors that can be targeted with treatment and services. And I don't think we've done any of that. That was 2021.
Well, this is where I would certainly defer to the Department of Corrections on kind of what they are, because again, my memory on this is not clear, but the nature of the risk assessments, both in the timing of when they're administered, the staff who are administering them, and then also the nature of kind of what the information is. Though I think that if I'm recalling correctly, part of it was around trying to assess folks in time to inform sentencing decisions, right? So you want to have a risk assessment pre-sentencing, if for no other reason than to determine if a person's on community supervision, are they getting conditions of supervision that align with their needs, right? So that you're not asking a person to complete a certain type of treatment program that has no bearing on their particular needs or what they're going through, and vice versa, that you're not missing something that would be essential to focus on while they're in community supervision. I think I don't want to understate the complexity of administering a pretrial risk assessment. And so that's also where, we have not really looked into what that would mean for Vermont. But certainly when you've got someone being arrested, and whether that's by a local police department or a local sheriff's office, in many places, they'll go sort of into the county jail, or there will be there are courts personnel who can administer those risk assessments. And pretrial risk assessments tend to be, right, Carl, I think shorter in nature anyway. They're meant to be administered relatively fast, in understanding that you're not talking about the sheer number of people who you might be talking about is such that you don't want it to take hours for each individual. But it would be interesting to learn more about what the logistics could be in Vermont that would facilitate some assessment of individuals before they're either detained or released back into the community, and then understanding what the conditions of release are that might need to align with the assessment. And then if there's any potential for supervision, again, for the, folks who are most in need of that, so that you're really targeting those resources effectively.
Okay. I think I have risk assessment. Wouldn't it also allow people to immediately go to diversion or some other, if they were determined that they might benefit? And wouldn't that benefit the whole system if the charge was moved to diversion right away?
Yeah, I mean, it's again, if it's an effective tool as an assessment and it's well administered, you can identify all kinds of things.
Right, it would need to be voluntary because the person hasn't been convicted of anything, but I somewhat remember talking about that with, and the Defender General at the time insisted, well, it was Matt, that it be voluntary, but it is to the advantage of the person. I don't know if we ever followed up, COVID hit after this report in 21, and I think that a lot of things fell by the wayside, but I appreciate both you and Carl being with us this morning. Are there any questions for Carl or for Ellen? Thank you so much. Really appreciate it. Carl, I believe I met you in Austin one year.
Yeah, I think so, Senator.
And didn't you know Justice Reiber?
Yeah. He and I was the state court administrator back when Lee Suskin was the state court guy in Vermont. And Chief Justice Reiber was chief back then and still is. He and I kind of bonded and met each other at our joint conferences. He was terrific.
Yeah, I can remember going to your office with Tony and the Chief Justice, and I thought that's where we met. But my memory's not as bad as
That's
I thought
pretty
it
good. Your memory is better than mine. I would not have been able to place that. Thank you for giving me that memory again. I miss the courts, and I was thinking about your questions about all this. I was looking at New Jersey while Ellen was talking to you. New Jersey is an older example of a state that's gone full tilt into a non-cash bail pretrial services model. And I think, like Massachusetts, New Jersey, the administration of that is in the judicial branch. So again, there's an issue of governance of whatever. If there's going to be some sort of new resource, there's at least a question whether that's a judicial branch or an executive branch resource. So something else to think about. And we'll send you some information on New Jersey in particular.
I'd worry about making it a judicial branch resource, just given the lack of resources in the judicial branch.
Yeah, probation.
Yeah, and that may be totally inapt for Vermont. But it is an option that some states go for.
Probation and parole could be
Yes.
a viable alternative.
Yeah, that makes more sense.
Because they take deferred sentences, for example, and supervise them, but they don't provide a lot of supervision. They just, person checks in, and I have a relative who was charged in New Jersey who's currently checking in once a week from Vermont to New Jersey and participated in substance misuse treatment, and it seems to be doing fairly well. But the system at least had that oversight.
Yeah, no, I think it's a really important part that's missing from our system, and that we'd see a lot more success. I mean, I certainly know, in my practice, how many people are calling, and I've got, probably a year-long wait list at this point. So like, how much of it is just a person's inability to navigate those really complex systems that would be gone if they had someone supporting them.
Yeah.
Well, thank you.
The last thing.
One other thought that hasn't come up yet, but you all have, to the extent that you do have bail and people who are plying the trade of bail bondsmen, maybe that you should be expecting more of those folks. They're supposed to do something for the money that they get. And that might be another avenue to explore.
Yeah, it's interesting. I'm not sure that.
Oh, I was just going to offer one thought, which is, and again, I don't know exactly how this works for the Department of Corrections, but in Vermont, but just we see this in jails all over the country, and I think it would be the same for DOC because of the short nature of a person's incarceration while they're awaiting trial. Just a reminder that those folks they're not getting programming probably, or they're not necessarily getting treatment while they're incarcerated. And again, this certainly applies to many jails. That don't have the resources to provide that. But even if someone's, it's hard to place someone in a program that might help them when they're incarcerated for a shorter period of time. So to what you were saying, Senator, about sort of needing help finding treatment in the community, to the extent that what's driving a person's criminal behavior and repeated criminal behavior is addiction, is mental health, or the two together. They won't necessarily get that when they're incarcerated awaiting trial. But with strong supervision, strong connections to care, they might get more of that in the community, which has longer term, public health, public safety benefits.
I don't think anyone, well, maybe a few people, but I don't think the vast majority of Vermonters want people incarcerated that don't need to be incarcerated. What they are frustrated by is the lack of accountability within the system to hold people, either in a setting or to require treatment, and the person participates in that treatment. And also the treatment needs to be available. That's another issue. But I think I have some ideas now and the direction of where this should go. I do think the bill that Carl was talking about, 150, I think it's 159, is really designed to bring about consistency throughout the court system. Because right now, some judges do it and some don't.
Got it.
But I think it goes back to the screening, it goes back to understanding who we're dealing with. You know, the judge.
Well, we will send you some more information. We're happy to update this. Like I said, we were drafting a memo, but now that we know more of what you all are thinking about, we'll include a lot of information about other state examples and systems that might be helpful too.
Yeah, I think there are cases where the judge doesn't even know who they're dealing with. They give a name, but it may not be their real name. And we've had also cases where I know of a set of twins who constantly fooled the system, who was guilty of what, knowing one was more likely to get incarcerated, the other was less likely, so they'd use that name and play the system.
That's hard to assess for, but I'm sure it would be interesting to try to get into the, yeah.
Both are in their 40s now and are doing fairly well, but I don't know why, what they started out with. But they did do that, and there was quite the fight between the two of them. I took the rap for you on this, and I happened to witness it. Anyway, thank you both very much. Appreciate it.
Thank you.
Our next witness is Christina on or no? Yeah. Christina, thank you so much for joining us. I do appreciate it.
Good morning, Senator. Thank you for having me.
And thank you for all your work when you were the.
Thank you. Oh, you're most welcome. It was an honor.
We're trying to understand a little bit about the federal system, which does not, as I understand, doesn't have cash bail, but does hold people accountable.
Yes. I was going to start by talking a little bit about the federal bail statute and just setting the table for how it works and the types of people that are detained and the types that are released, and then talk a little bit about how U.S. probation supervises people and the tools they use. Would that work for the committee?
Yeah.
Okay. So just to start out on the federal bail statute, in theory, any offense is eligible for detention. So if you can show that somebody is a danger to the community, a risk of flight or non-appearance, or a risk to tamper with evidence or witnesses, and that no conditions can be set to cure those risks or ameliorate those risks of danger or non-appearance, then that person can be detained pending trial. It's an individualized assessment. There's no formula that you plug in and the judge spits out an answer. It's truly each offender is taken on their own individual circumstances. There is no money in Vermont, no posting cash bail, except in the rarest of circumstances. I can think of one offender from Quebec who committed some type of offense, and the judge gave him a chance to go back to Quebec, but they had to post bail. But for all intents and purposes, there's no money in Vermont federal court. So having money is not going to buy you release in federal court in Vermont. I understand that for large swaths of state offenders, that is the only tool prosecutors have to hold certain types of offenders in state court. So in federal court, they look only at risk and whether conditions can be set to cure the risk, to keep the community safe. So, you could look at it as a system of equality that also promotes community protection. There is no violent element, so to speak. that is required to be considered ineligible for release. So those who commit child pornography offenses, those who commit fentanyl trafficking, those who illegally possess firearms, those who may abuse a vulnerable adult, even certain financial crimes, all circumstances depending, could be eligible for detention. So you don't have to have one of the big sort of, I think they call them in state court, the big 12 offenses. There doesn't have to be per se an element of violence. Some of the key factors that the judge will look at in deciding whether someone needs to be detained or can be released is their ties to the community or lack thereof. So their ties to Vermont or lack thereof. Whether they have a history of not appearing in court. In order to be detained on that basis, in my experience, you would have to really have a serious history of not appearing in court. If you have a very long criminal record, it might be an indication to the judge that you're not, there's no reason to think you'll stop now, could be held on that basis. If you have multiple instances of the same offense, if you have substance use disorder, you will be held at least temporarily. If you have not much of a criminal record, you can present a plan to be released into rehab and aftercare. And so you may be held temporarily if you have a severe drug addiction, mainly heroin addiction. But you do have an opportunity to present a plan for release. A big one, and I think it relates to what you're talking about in this bill, is if you are somebody who has offended and you're before the federal court on a new offense while you're already under conditions of release. So if you're already under court supervision, whether you're on pretrial release for another offense, or if you're on some form of probation for another offense, and you're back in court with a new offense, meaning you have not followed the conditions a court already set, that will weigh pretty heavily in favor of pretrial detention, because the court will conclude that you either cannot or will not follow conditions of release. Now, when you can be released, and I want to be clear that many, many people are released, not everyone is detained, even though the eligibility for detention is much broader in federal court. But when you can be released because the judge finds that there are conditions that can be set to assure the safety of the community and your appearance in court, then you are assigned a pretrial probation officer to supervise you. And they assign the probation officers by geographic area of the state. So somebody will have the Southeast, somebody will have the Southwest, somebody will have the Northwest, and so forth. I will just say, shout out to the U.S. probation officers. They're just excellent public servants, and they are the absolute best resource a defendant can have because they want them to succeed, and they are there to help them succeed. And what they look for, generally speaking, is oftentimes they want to see someone working. If education is something they could pursue and want to pursue, they want to see them getting education. Of course, they're looking to be sure they don't reoffend. They want to see them getting supports they may need, whether it be mental health counseling or drug treatment. And they want to see them not using drugs, especially if their offense was a drug-motivated offense. This is sort of generally speaking what the U.S. probation officers will look for. The most important thing that they're looking for, though, above all else, is to be truthful. If you're truthful with them, a setback is not going to land you in prison. If a defendant is truthful with the probation officer, they'll work with them and give them chances to comply, and they will take that honesty into great account. And when a defendant has a good relationship with a probation officer, really wonderful things can happen in their life. The standard conditions that a judge would set, there's a number of them, but of course, first and foremost, if you're released, you can't reoffend. If you commit a new offense, you're likely to be detained pending trial. No possession of firearms, surrendering the passport, no drug use, that's very standard. And then there are some case-specific conditions that can be set depending on who the defendant is and what they did or what they're alleged to have done. And the probation office will enforce these conditions. So those can include a curfew, like I said, educational programming, drug testing, drug treatment. There can be restrictions on where you live, on where you travel. You might have to wear an ankle bracelet. You might have to be in the custody of a certain person. Regular reports to probation can be required, reports to their office. They might decide that you need mental health treatment. For financial offenses, you may be forbidden from taking out a loan. You may have to show your bank statements to the probation office. For internet-based crimes like child pornography, there will always be either forbidding of access to the internet or internet monitoring software. For certain offenders, you may be forbidden from having contact with certain populations like children or other vulnerable populations, vulnerable adults, for example. You may be permitted from working in certain fields. It is possible for the judge to set bail, but again, that almost never happens. And it's, as a matter of course, something that's avoided in federal court. I think because of the inequality that arises from people of means being able to buy their way out of jail. In terms of how the tools that the probation office uses to monitor offenders or alleged offenders, they have broad discretion in how they enforce the conditions set by a judge. They can start with one method and switch to another. The discretion is very much theirs. For drug motivated offenses, those who have substance use disorder, they may need to be detained initially in prison. They will have their initial withdrawal, which is difficult for them, but it helps to set up the possibility of success. And what happens is, if really your only factor supporting detention is substance use disorder, you can get into rehab. It'll be Valley Vista or Serenity House, followed by an aftercare program, which would usually involve the Howard Center or some form of IOP. Some people who don't have a place to live after Valley Vista or Serenity House could live, if their lawyer could try to get them into Jenna's Promise or one of the sober living homes. I recently went through that process with somebody I'm representing now. The probation office will get releases from the sober living homes and from the rehab centers so that they can learn what's happening with the defendants in these programs. So if somebody flees one of the programs, just absconds, which unfortunately happens, the probation office will know right away. And of course, they'll know about successes and completions of the program. The probation office will also conduct random drug tests for those with substance use disorder, so you just don't know when it's coming. And there's no way to predict it, so they're very effective in monitoring compliance. With certain offenders, they'll put a sweat patch on them, and in that case, samples will be collected continuously over a period of time. But there are, of course, other types of offenders. And like I said, mental health counseling can be required, internet monitoring. Sometimes the probation officer will visit the site of someone's employment to check in on them there. They will conduct random home visits just to see how things are going at home, curfews and so forth. The ankle bracelet for someone who might present a real risk of flight. Again, honesty is the most important thing they're looking for. I have had many instances, both as a prosecutor and a defense attorney, when somebody is confronted with drug use and they're given another chance because they're honest about it. If the probation officer feels like they can work with somebody, they will work with them. Obviously, there's an endpoint to that. You can't just keep using and being honest about it, but they really want to have a dialogue. They understand no one's perfect and people don't succeed always right off the bat. And then for those folks who are released, but they have shown that they can't be supervised, they've violated perhaps more than once, or they're dishonest, just persistent violations or dishonesty, then the probation office can ask the judge to revoke their release. So they write a report to the judge, which the prosecutor gets a copy of, explaining everything that's happened, the history of the matter, and what the violations are. And then the government gets that report, and the prosecutor can move to revoke release. An arrest warrant can issue. The person is picked up by the marshals. And then they go before the judge, and the judge can either decide to re-release them because they have a new plan, or they convince the judge, he or she, that they will comply if they're released again, or they may be held for a period of time while their lawyer figures out a new plan, or they may be held to the end of the case at that point. So that's just hopefully a somewhat helpful overview of how the process works. And if I can answer any questions of interest to the committee, I'm more than happy to do so.
Senator Bowlsby.
Thank you. Thank you so much for being here and giving us that sort of lay of the land. I've got two questions, and one is just a lack of understanding on my part. If crimes charged at the federal level are generally more serious than crimes charged at the state level.
I don't think so. I mean, I don't think it can be said so simply because, you know, you can charge murder federally. I think of the horrible Michael Jakes case where there was internet used to kidnap poor Brooke Bennett, and she was viciously murdered by Michael Jakes. We charge that federally because of the instrument of interstate commerce used in a kidnapping, but most murder cases are charged by the state. Most murder cases won't have sort of some way to get a federal hook to make it federal jurisdiction. Now there are ways, but there are ways to charge murder federally or effectively charge it federally, but most murder cases are charged by the state, as are most rape cases. So I wouldn't say necessarily that federal offenses are more serious. It sort of depends. We certainly have more firearms, more federal firearms laws, more federal laws prohibiting certain conduct with firearms than there are in state court. But I wouldn't necessarily say it's as simple as that. It sort of depends on the offense, but many very serious offenses, perhaps the most serious, are charged in state court.
Yeah, I think I actually oversimplified the question, and I think sort of what I was getting at is a lot of our less serious crimes are charged at the like shoplifting would be unlikely to ever be charged at the federal level, and sort of those more petty property crimes would never be charged at the federal level. So I think that's sort of what I was getting at, is like a lot of the less serious crimes would not be charged at the federal level.
Sure. We do, I mean, federal court, when I say we, I'm not a prosecutor anymore, but, and sometimes it's hard to stop saying we, but federal prosecutors do sometimes bring misdemeanors. I just represented a client who had her charge reduced to a misdemeanor, but I take your point. Certainly there are a lot of, petty crimes and misdemeanors that would be charged in state court and not federal court.
Awesome. And then my other question around this sort of idea of detaining someone so that they go through detox, is there any data tracking if there's an increase in rates of overdose death after that process?
After the process of detoxing in prison?
Yes.
Not that I'm aware of. The experience of the judges, the probation officers, and probably people of the bar on both the prosecutor side and the defense side is, if you have someone come into court and they're sick, and it's a horrible thing to witness, releasing them, they're not going to be in a frame of mind where they can do rehab because they're so sick that they need a next fix and, a next use. That's what the experience has been. So to set them up for success in Valley Vista or Serenity House, they just can't go in still on drugs effectively. But that's why it's so important to have buprenorphine in prison. And the client that I most recently worked with that I'm thinking of got on buprenorphine after her initial appearance and was able to think clearly and talk about options, shortly thereafter.
I have a question about the probation officers who supervise. Do they have also regular probation caseload?
No, so they have, so there are, the tasks are divvied up amongst the probation officers and they'll rotate to different assignments sometimes, but there are a set of, when I say a set, I'm talking about 2 or 3 who supervise pretrial. There may be some overlap, and then there are some people who supervise post-sentencing. We call that supervised release in federal court, but it's basically probation. So they're usually assigned to one of those desks, and then there's another set of them who write the equivalent of a PSI federally. We call it a PSR. But I do think there is, while there are some people who do a little of both, I do think that there's a lot of division of labor too.
Senator Norris.
Yes, hi, Christina.
Hello, Senator. How are you?
Good. How are you doing? It's been quite a while.
I know. Nice to see you.
It's good to see you. Along the lines of Senator Sears' questions, it appears as though Vermont doesn't have any supervision over individuals from violations of conditions. And you had mentioned your federal probation officers, and they were broken up geographically or whatever. Do you have any idea or ballpark figure as to how many you actually have in the state? And if so, what their caseload may be in case we choose to entertain something here at a Vermont level?
If I tried to answer that right now, I'd be guessing, but I'd be happy to research that and send it to the committee. I'm sure that the volume, the ratio of people they're supervising to the number of people, the resources that the probation office has is, I would suspect it's far better in federal court than what you have in state court. But if you're looking for the rough number of federal releasees and the number of probation officers that are monitoring them, I could certainly look at that, but I'd be kind of guessing, be an educated guess, but I would say there's at least 3 supervising, and the number of offenders, it could be 2 dozen, 3 dozen more, maybe. I'd really have to check to be sure.
That's fine. I appreciate that. I mean, if you do have the time, don't go out of your way here, obviously, but I think it's something this committee would be interested in.
Mm-hmm.
Yeah, I do have one other question.
Sure. Thank you.
You mentioned that one of the conditions is somebody comes before the judge again and they have a new charge. It's like an automatic, you're going to jail. Did I hear that correctly?
Well, nothing is automatic, but nothing is automatic, which is one of the things I like about it, because it really does allow the judge to consider each offender on their own individual circumstances and everybody gets a chance. So there's no automatic, but it would not be a point in someone's favor if they were released on conditions and were charged with a new offense of any kind. I mean, that is the surest way to go back to jail. And drug use, I'm not talking about offending by possessing drugs by using them. That's not what I mean. I mean committing put that type of offense aside. Some other offense that's actionable aside from just using drugs. So, for example, I had somebody when I was a prosecutor who was charged with drug trafficking conspiracy and was a cooperator, but while on release committed a DUI. That person went back to jail for the remainder of their case. Anything, and to be honest, that is the exception, not the rule. We don't see a lot of people in federal court committing new chargeable crimes while on release. But if you do, that's going to be a tough sell to stay out of jail.
Senator Bosky.
And so I'm going to try to frame this question in a way that makes the most sense, but when you're on conditions of release, there are these sort of technical things that become crimes only because you're on conditions of release that wouldn't be crimes if you're the regular public, like not going to treatment, because that's now a violation of conditions. Would someone be, well, again, not automatically, but likely to be returned back to the federal jail system if they commit one of those more technical violations, or would the probation officer work with them to solve the problem?
It either could happen. Most times, if you abscond from treatment, remember the question is, can conditions be set that will assure the safety, public safety and your appearance in court? I've never seen someone abscond from treatment and not go back at least temporarily until a new plan could be formulated. That being said, it really is there is no set formula. There is no set of rules. There is no hard and fast, if you do this, then that. So it could be the case. The probation office is never required to violate anyone. It's in their discretion. So there's a large amount of power vested in the probation officer, but failing to go to treatment, certainly, especially if the probation officer has worked with you on it, if there's problems with transportation, if you've been given a chance to work with them on it and you're still not following that condition, then they could report that to the judge. It's always ultimately up to the judge to decide, though. The judge has released people again when the probation office wants them detained. The judge has detained people that probation has thought could still be released. So the probation office will have the judge's ear, and oftentimes they're in unison in their view of it, but it always depends on the circumstances.
Thank you.
Thank you.
And not that this is probably overly technical, but it wouldn't be a new crime. It would just be a violation of release conditions. So it's not like they'd have a new criminal charge or conviction on their record. It would just be a violation that could return them to pretrial detention or send them to pretrial detention.
That's helpful, and I think may actually be different than our system, because in the Vermont system, I'm looking at Ben, because I think he may know the answer to this. It's a chargeable new docket violation of conditions of release, yes?
It's up to the discretion of the prosecutor to charge someone for a VCR.
But it can be a new crime?
Yes.
Okay, thank you.
You're welcome.
Any other questions for Christina Nolan? Thank you so much for joining us this morning. We were found it very okay.
My pleasure. Thank you.
Thank you. Lieutenant Daniels, do you have any comments, questions? On bail?
On bail? Yeah, there's a couple things that I was gonna.
Come on up.
Yeah.
We join you to join them. We ask you to join us. Let's join you to join us. It's been a long day, but.
It's gonna be a longer day if it's been a long day. It's been after 10.
Yeah, I just touching on the federal, as far as the drug investigations that we do, yeah, I alluded to it. Last time I testified under S58 was 25% roughly of our cases we push federally. In that 25%, there are a number of individuals who have been charged in the state level several times, and they keep reoffending. And we will talk with the prosecutors and kind of advise them, we have, 3 separate instances of sales, arrests, convictions, and then we bring it to the federal level at that point. And they're usually held and they're usually in treatment for a lot of these folks.
Tell me what it's like to be a leader of a force, as you are the captain, and what it's like to have to watch somebody get released over and over again.
It's challenging. I mean, the folks that are on the ground actually doing the work,
Yeah.
they have a tremendous amount of compassion for these individuals, and it's frustrating. Myself, they get calls from mothers pleading to put their kid in jail because they know that's the only option that's going to keep them alive. They're not capable, as Christina alluded to, on making that decision in the mindset they're in, and there's no system in place to force them into treatment. So it's challenging, at least with all the cases that we're dealing with. Some people, the traffickers that aren't necessarily suffering from opioid use disorder, that's a little bit different. They're feeding off other people's dependencies. Their only motivation is monetarily. And then obviously the violence that follows them up to the state as well. But overall, it's frustrating seeing people. I mean, these are mostly felony arrests that we deal with. Being released on conditions. It's not that they're released, it's that there's no system in place to push them into treatment. And one thing that I really appreciated in S195 was the section of under the conditions having treatment being one of those conditions. The individuals that we arrest and talking with them, they want treatment, they do, but they don't have the mental capacity to even get through the day. So for them to know in their minds, I'm going to be a minimum of 30 days without using is terrifying to them. And that's their words. So opening up an avenue for them to get into treatment and be successful, which we have found numerous cases that we've pushed up to this federal system. They go through the federal treatment. There's oversight, and there's post treatment, which is proven very successful, and a lot of people have gone that route.
I think you're right. What's frustrating to me is that certain times that people are amenable to treatment. One of those is when you're under arrest and you're realizing that it's up, people know now, and you've been caught, and you might be more amenable to treatment, but if you have to wait 3 weeks to figure out that treatment or get into it, now found a lot of excuses to not bother.
Right, and I think when people are released on conditions, there's no window in there to have a clean mind, or at least start to have a clean mind to really devote energy and time into getting that treatment from what we're seeing anyway.
Yeah, I don't think the supervision has to be all that intensive. I think it just has to be there.
So there was
Like I said, with a relative of mine who had to call in once a week from Vermont to
Correct.
Jersey.
I don't know if you remember, I think it was 2015 in Rutland, retired Colonel Baker was the chief at the time, with Project Vision, which is very similar. It's a drug court program, very similar to the federal system in the sense that, you know, there was oversight provided by the police department and probation. And and we actually submitted some of our cases into that as kind of a pilot for people selling drugs that were also addicted to opioids. It was fairly successful because there was that oversight. And when they went into court to face the charges, they would give the option on pleading guilty and entering into a rehab drug rehabilitation. And if they were successful, their cases were dismissed. Or, you know, it would be a more of a probationary period while they're in treatment.
It's interesting because Jim is now in Bennington. As you know, he lives in Arlington, and I see him frequently. He's now not running, but advising Project Alliance in Bennington, which has a lot of similarities to Vision, right or not. But he's still active, and well, I give him credit, I give him crap for it too.
That seems to be the biggest hurdle is having enough people to provide that oversight and that help for the.
Yeah, there isn't any, we don't have any system that it's, you're incarcerated one day for lack of bail or whatever the reason. Court decides to let you out and you're free and you have nothing. No supervision. You might have lost your job, lost your housing, whatever, and you're out. Is it any surprise they get back into trouble?
Right.
And the same is true when we put people on conditions of release. There's nobody supervising them, so you know, they're back out doing whatever they do.
And sorry, I didn't mean to interrupt you.
Anyway, that's my take on this.
Yeah, well, and adding to that, and I don't know if you have the statistics around this for the cases you see, but I think one of the things the tragic things we see is this increased rate of overdose death after people are released. And I don't know, former U.S. Attorney Nolan spoke to the sort of forced detox. Is that a system that we're utilizing in Vermont as well, of like holding someone just so they detox and then releasing them?
I guess I don't, from what I've seen in a very small example, is a lot of that is for people going into, that we've seen people overdosing when they go into treatment, or if they're incarcerated for a different reason, they aren't provided treatment while in the facility. They get out, they had a 20 bag a day habit, but they haven't used in say 20 or 30 days. They get out and they use 20 bags, but they're not starting out at a more moderate level. As far as some of the larger seizures, I know this has come up before, like, we see just say like 20 grams of fentanyl heading up to St. Johnsbury or Bennington. We don't see like a bubble of overdoses, and we track that.
Okay.
It's, I don't know, I don't think that's, if there's treatment available, I think that is beneficial to get them off it and not go back to using. One of the things just kind of stuck out to myself in talking with Tucker Jones was our Title 23-1201 statute under DUI. We have very strict conditions if you're convicted of subsequent DUI, and one of those include alcohol counseling and treatment. There's no options. Like, that's what you're mandated to do under these conditions. And it's just my feeling like that we're kind of right there with this opioid problem because it's affecting others other than the person using, and to get them actual help.
That's helpful, and it sounds like the vast majority of the cases you're dealing with are not those individual person who is incarcerated because they shoplifted, haven't used for 20 days, and now overdosed. That's not really the population you're working with. And I think that the system that we're talking about of support and services might actually help end some of those post-incarcerative overdoses because we would be providing those types of treatment services within that system. Thank you.
Well, I think the risk, there are, risk assessments, and there are risk assessments. But the simple risk assessment to determine if it has to be voluntary. If the person's willing to go through the risk assessment, then you can determine what's the best, because a lot of them have mental illness, as Ellen mentioned, mental illness going along with substance issues.
Yes. Yeah, and I provided everybody with a list. I gave some of these examples during my last testimony. This is a snapshot. I think there's 4 pages of just examples of the bail issues or conditions and violations. And since the last time that I spoke, one that I found out of Bennington really kind of stuck to me. It has nothing to do with that I'm aware of, to drugs or opioids. But it was in September. It was a 5-year-old was sexually assaulted by her mother's boyfriend. So mom brought her to the hospital to have a SANE kit done, and the boyfriend was arrested. It was like a Friday, and he was released on conditions on Monday. The following day, he was arrested again for harassing the mother. Went back to court, was released on conditions the same day. 3 days later, shuts off the power to their house. Type of harassment again, was arrested. Went to court, didn't show up to a prior court date, had a warrant issued for him, went back into court for the warrant, and is now currently on release on conditions. It's just, it's tough to swallow.
Especially that particular fact pattern where you've got people who are being targeted again and again. Not that it's any better if it's a store that they're ripping off, but here we've got
A victim,
exactly
5-year-old.
I think we need to read Pratt and understand what the court has done and see how we can overcome to get where we want to be, how we do this in light of the Supreme Court, Vermont Supreme Court rulings. But Senator Sheen and Senator Morris.
Thank you for that last anecdote, because it kind of dovetails onto what my main concern is when it comes to conditions of release, which is really coming down to the question of how many times can somebody commit simple assault or domestic assault or any other misdemeanor violation that has an element of violence, and when there's evidence that they are likely to do that again, how many times should someone be able to do that before they are temporarily separated from the people who are at risk. And that, I think, is, at least for me, that's the core of the question when it comes to the work that we're doing on conditions of release.
Senator Norris.
Yeah, thanks, Lieutenant, for being here. I've got 3 quick questions. One is just a point of information. Is the state still broken up regionally to 5 or 6 districts? You used to have them broken up into like a Northwest district, regions is what I was saying, regions.
For the drug unit?
No, just the state of Vermont, just have them broken up into
Yeah.
5 different regions.
I believe so, yes.
Okay. Thanks. That was just something personal for me. I noticed in looking at this, you have pushed a couple of different cases up to the federal level. And my question there is, I guess, why are Vermont laws too soft on crime and federal laws address them? Is it because of the backlog in our court systems, or is it because of the federal supervision that they do offer for this? And my second part of my question is, who makes that decision? Is it the unit's decision? Do they work with the state's attorney or go directly to?
So to answer the 2-part of your first question, so we have cases that, we'll consult with during the investigation with the U.S. Attorney's Office. At a certain point, they will adopt or take that case even before we arrest somebody. They reach a higher level. We have sufficient laws in Vermont. The problem is the sentences aren't being imposed. And that's more for like trafficking and for violent crimes and things of that nature. What I was alluding to before was when we have this continuous turnover of the same person, the person who's providing housing for multiple drug dealers, we'll arrest the drug dealer. Within 2 days, they have somebody else up in their house doing the same thing. We arrest them. We charge them in conspiracies through the federal system to stop that continuing to happen. Seeing the outcome in these individuals that are actually addicted to opioids going through the federal system, I don't have a number for you, but comparable to our Vermont system is successful from what we've seen. Not everybody makes it through, but the good thing about it, if you fail the first time, sure, you may spend a week or 2 or a month in jail, but then you're reintroduced into that program. And we've seen a lot of success in that. Can you repeat the second part of your second question?
I can remember the second part. We addressed, the Vermont bills as they exist, Vermont laws as they exist versus the federal. And is it because the federal supervision has a better, I think you addressed the first one as far as the unit's decision to go federally with these charges or stay run by the state's attorney's office?
Yeah, so I believe the federal system, the courts run the probation, which is unlike what we have in the state. So there is definitely way more oversight and assistance to the individuals that are going through the federal system. And sometimes that is a weighing option that we have on pushing some of those cases up.
Okay, thank you.
Is there, in your view, and maybe you don't know, and that's a perfectly okay answer, any benefit to creating a system of support through the judiciary versus DOC, or is it really just about the support?
Quite honestly, I think it should be combined. I think they both should have a vested interest in that, law enforcement as well. Being able to communicate throughout that process benefits law enforcement because we're not hopefully dealing with these same people reoffending. Same with the court system and the judicial system, and then through the treatment facilities. We all, I think, want success for these folks.
I guess my question is, do you think that I think, yes, they should all be communicated and working together, but do you think it makes a difference on success where it is housed, whether it's housed under DOC or housed under because the federal system is housed under judiciary, unlike what we do in Vermont. Yeah. And I think we could certainly look at that if that's the best outcome. To me, for economies of scale and kind of what it makes the most sense to house it in DOC because that's where our existing support services like that are, but I'm wondering, I guess, if your opinion is that it makes a difference.
I think, I think it comes down to budget and being able to create a whole new system that's gonna have that oversight. If those systems are in place and within the demand that it would see, it's already built. If we can implement that structure within, maybe certain parts of the facility in the prisons where they're not in the population with violent offenders, but they're in other sections that are more specified towards treatment. I think it would be an option, but that's not my.
The problem is you can't require treatment. And what always frustrated me, when I ran the rehab delinquent kids, was if we got a kid who hadn't been convicted of delinquent act, we couldn't do certain things. We couldn't get him one of the things we used to do was force the kids to admit their problems, and as exhibited by whatever they're accused of having done. And I've always used the example of the kid that didn't break into the building. He just leaned against the door and it came open and he went in. That's not breaking in. But trying to hold kids accountable. We had a kid who was accused of a sexual act with a female at the high school. And until that case was settled, which was almost 6 months, we couldn't talk about it. We couldn't, get him to talk about what he'd done, et cetera, et cetera. So it's always hard to do something because they're in jail and they can refuse the treatment and whatever. But if they're out of jail and the treatment is keeping them out of jail, they're more likely to participate. That's
And
a crazy system, but it's the way it works.
just and based on the little bit of research that I've done is also a factor that is the post-treatment, right? And going back into those familiar groups of people or areas of town that started these people in that trend anyway, trying to keep them on a cleaner path is the challenge that I've seen.
I just asked Ben to look at this decision by the Vermont Supreme Court from 2017 and see if that might be the basis of some of our changes. And to look at a system that provided 6 probation officers assigned to the court statewide. And I know it's an increase in the governor's budget, but he said yesterday we had to do something about public safety.
I'm not sure this is what he had in mind, but I like it.
If you have actual supervision and you follow more the federal, where if there are new charges or violations, it isn't automatic, but you're likely to face some prison time and somebody's supervising. It's much different than if nobody's supervising. You also have somebody who's supervised that you're going to treatment, you're doing something. It may only be a phone call. And I know people who were on deferred sentences who are only supervised by a phone call from the individual weekly to the probation department. And the only question is, have you gotten any more trouble? If the answer is no, fine. If the answer is yes, you better come see me.
I agree. I think that would be a step in the right direction.
So I think actually, I don't know if you can use opiate funds, stuff like that, but it's time to look at getting some kind of supervision for that pretrial detention, pretrial group in the community. Because I know my constituents are up in arms if they see somebody released.
Yeah.
I think the standards set in the community, and we've heard it from people that we've arrested, that they know that there's no repercussions for violating their conditions. If they get caught, they're going to go back to court and they'll have more conditions imposed on them. And possibly by imposing some oversight and consequence, it doesn't take long for word to get out that there's repercussions.
I think I was in court one day for something completely different, and there was a case in front of me of violation of conditions. It had to do with firearms, and the person was not supposed to possess any firearms. It was a drug case, and the police had found him with like 7 new firearms in the apartment. Judge said, you know, he's not supposed to possess firearms, but just set him up.
Yeah, and that's another.
Oh,
cut you off.
Go for it.
You know, the firearm, I did have, you know, a small blurb, and I alluded to this before, that the word is out that there's really no charges for possessing a firearm with drugs, without drugs. And that's coming from people that we deal with again. So it's not us interpreting that is out there, and that's why the gun thefts, straw purchases are so prevalent in the state. You know, we're trying to mitigate as much as we can on preventing some of these users that we charged from being able to purchase firearms temporarily. But yeah, I feel like until we have some laws in place to hold at least drug traffickers accountable for having weapons and their product together, we're going to continue to see that upward climb in gun violence. And
Senator Sheem and then Senator Mahowski, and then we're gonna take a break.
Just a quick comment on, I think something you mentioned a few minutes ago about supervision for some of these drug violations. It might be worthwhile hearing from the judiciary about the proposal that they mentioned for the statewide drug docket, which would cause a lot more supervision. My understanding is for drug court, you have to go, I believe it's every week or every other week to court, get drug tested, meet with folks, and meet with therapists, meet with,
But I don't think you can be in drug court until you've been convicted.
No, I don't think that's, no, drug court is a separate path where where you're charged with the crime, and I'm oversimplifying it, but it's the sort of proposal where it's, all right, go through drug court, and we will either lessen your charges or completely dismiss your charges if you make it through this year-long process.
incentivizing, going through the process.
Can we invite the
Like a
judiciary
diversion.
next week to talk
Like
more
diversion,
about the
almost.
drug court?
Simplifying it,
Yeah.
going through this program without.
As part of the bail. If that's true. I didn't realize, I thought you had to be convicted.
We should probably also hear from probation and parole and the VSEA about their capacity or to take on new positions. But that was not actually my comment. My comment, I mean, it is my
We know what
comment.
they're gonna say.
I think it's important to hear it.
Yeah, you're right. But they're gonna say no.
I don't know,
Probation and parole say no.
maybe.
I mean,
Steve was there, but more numbers.
say no. 'Cause they've been told to say no.
Yeah, but the other thing that's come up, and I'd love to have sort of conversation around in this space, I know I've spoken to my state's attorney's office and they're their desire for sort of like caseworkers within the state's attorney's office or the judiciary to sort of help navigate, and maybe probation and parole would do that, but sort of helping someone to navigate all of the barriers to housing, accessing treatment, and their staff doesn't have the capacity to do that.
Yeah, my idea about supervision doesn't necessarily mean that it's just supervision. It's
Right.
also helping to understand what's available that you have, Serenity House, or you have Valley Vista available, or whatever.
Yeah, and I want to think holistically, and like I said, maybe probation and parole is part of why I want to help them
Maybe it's
in.
not probation and parole, maybe it's assigned directly to the court, I don't know.
Yeah.
I think you need some group that is responsible for that group of people who are out on conditions of release. If there's no conditions of release, then you don't have some, assuming the court is not found a serious
No, and I'm not opposed to probation and parole. I think it's a both and
I
approach that I'm trying
I
to.
came up with probation and parole because that's what Massachusetts does, but it doesn't.
Well, I agree with the 6 persons, there has to be consequences.
Pardon me?
If we fund these positions, I mean, there has to be consequences, if someone's found in violation of their,
I'm
through these
assuming
probation and
that something.
parole officers.
At
Well, we
least-
assumed they would in the courts too, but it's not, so.
Pardon?
We assumed that it would in the courts too, but it's not. 47 VCRs and 90 some on in Erie County, whatever else. In other words, if we're gonna put them out there to supervise these individuals, and they do find something where they say you're going back to court, I don't need them released on, or I prefer they not be released on violations of conditions again, that there's actually some bite with this bark that we're looking at here.
I agree.
Yeah.
Although I don't know what the bite is, but it should be some.
I think it's going to take time of going through every single condition in 7554 to see what is reasonable and makes sense. I mean, if it's, I mean, in my opinion, if somebody isn't making it to rehab or, to their therapist, does that warrant being detained? I don't think so, but somebody is, committing 7 domestic assaults in a week.
Trafficking weapons.
Yeah, so.
Well, if you have new charges, I think that's different from not, participating in something. Much different. It's when you got new charges. That's when, the court needs to look carefully at whether or not you should remain in the community.
2 minutes, I'll walk with you.
I do think there should be some discretion though, because I think, even
Can
new
I come find
charges,
you after
stealing
I-
diapers for my
It's not
baby
that
is different
important,
than
right?
assaulting my partner.
Order what to do anything.
All right.
I think
It's
you're
gonna take 30
probably right. I
seconds.
think that goes against the whole
Still.
3 branches of
But I
government.
can't,
We'll do it right when
right off, 30 seconds.
Perfect.
All right, we're gonna take a break until